Hey there, YouTube fans, it's Mike Palumbo. I want to bring to you today a quick legal lesson about the City of New York traffic court system.
If you get stopped, we can help you attack that ticket. Call today, 877-99-NO-TICKS.
So, in a previous video I did, a couple weeks ago, I talked about generally how we do traffic tickets and how we focus on trying to do a plea bargain versus a trial to negotiate down to a non-moving or a lesser moving violation. And I'll link that video. You can watch that video after this one. But all that's true, except for the City of New York. In the City of New York, the traffic court is not part of the city court system. The New York City Traffic Court is literally called the New York State Department of Motor Vehicles Traffic Violations Bureau. So the court you're in is not a court of law where the criminal procedure law applies, where the judges are elected, where you can make a motion. You're actually before the New York State Department of Motor Vehicles. It's an administrative proceeding. The authority they have to adjudicate these tickets runs to the fact that they have the authority to give you a driver's license. You see, when you accept your driver's license, you agree to not violate any vehicle and traffic laws. So when it's alleged that you have violated a vehicle and traffic law, the New York State Department of Motor Vehicles can adjudicate that complaint. Most times, what they've done is they've given the authority to the local town, village, and city courts, and non-New York City courts like the city of Yonkers. They've given them the authority to handle that adjudication. And because you're in that court, you have constitutional rights. You still have constitutional due process rights, but they're less so. When you're in that court, it's an administrative proceeding, and they're only taking action against your license. That's the fact that you have a driver's license or you drive on the roads in the state of New York with an out-of-state license gives them that authority. And the main difference is you can't plea bargain in New York City. Every case goes to trial. What I tell my clients in New York City is, look, unless you fight it, you're found guilty as charged 100% of the time. Just because you fight it doesn't mean you're going to be found not guilty. See, the only way of avoiding points and the conviction is to have the ticket dismissed in New York City. That's it. Now, I'm not saying that you're going to lose the case, but every case goes to trial. So yes, clients do lose in the City of New York. You're not going to win every single tennis match. It's a bilateral competition. You know, you're going to win some, you're going to lose some. But the only chance clients have in New York City is to fight it. Now, what we do in New York City is different than the rest of the state. We postpone the trial back as far as we can. That keeps our client clean as long as possible. And what that does is it mitigates or avoids the insurance increase win or lose the case. Because points hit the record on the conviction date, but the insurance look back period is from the date the ticket was written, not the conviction date. In other words, if tomorrow we go to court in the Bronx and a client was found guilty and the ticket was written 3 years ago, the ticket was written in November of 2017, and now in November of 2020 they get found guilty. They're through the entire insurance increase period. So their insurance company still cannot increase their insurance. Contrast, if they pled guilty 3 years ago, the insurance company would have picked it up. In these last 3 years, they would have surcharged them. So it takes, with this whole COVID thing, it's been taking a lot longer now to get cases to trial. It was routinely taking a year and a half to 2 years. But now, they've adjourned so much stuff to the end of next year. It's probably going to take now 3 to 4 years to get the cases to trial. So, so what we do is, we postpone it back, we go to court, we ask for adjournments. Sometimes I can just do it online, but we manage the case and get it down the road as far as we can. And then at the end of the day, you got a good shot of winning. Look, half our clients are found not guilty. It's like a 50-50 split, so that's not really too bad. Also, a lot of times, you might be charged with a 6-point speed doing 21 miles an hour. 21 miles an hour over the speed limit. At 6 points, doing between 21 and 30 over the speed limit. Well, I've never had anyone found guilty as charged when they're doing 21. When they're found guilty of a lesser 4-point speed. So that's the case where we would reduce it, but not through a plea bargain, but by through cross-examining the police officer, undermining their case, so they can't prove like a 1 mile differential. They can't prove exactly 21 over the limit, but they can still prove you're speeding. So we get knocked down that way. So a lot of times some people have like a 23-mile-an-hour speed, that's a 6-point speed. They're found guilty of a 20-mile-an-hour speed, or they'll have a 33-mile-an-hour speed, which is 8 points, and then they're found guilty of a 6-point speed, or they'll have a 43-mile-an-hour speed, which is a suspension, and then we get them found guilty of the 8-point speed and avoid the suspension. Another thing we do a lot of times in New York City, multiple tickets are written on one stop. Very rarely are clients found guilty of everything, of every single ticket that was written. So if you've written of 2, 3, or 4 tickets, usually a couple of them are dismissed. So that's another way we reduce the convictions, even if the entire case is not dismissed. So that's what we do and how we do it in New York City, and how that court system is different. Again, thanks for watching. If you get a ticket in New York City, give us a call. We'll take care of it for you. You won't have to go to court. You won't have to come to our office. We do everything for you.
Don't just pay that ticket. Go to attackthatticket.com or call today 877-99-NO-TICKS.